Warm greetings to one and all present here. I hope everyone is doing good. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be enlightening you all on the topic Alternate Dispute Redressal and Emerging Trends. Let's begin with an introduction. ADR means Alternate Dispute Resolution, which includes various methods of settling a dispute without getting into the intricacies of the court. It is a method where parties try to resolve their disputes privately in front of a third-person expert. The decision is binding on the parties, like the decision of the court. It includes methods like arbitration, mediation, conciliation, and negotiation. These work on the principles of justice, legal aid, and speedy trial as given under Article 39A of the Indian Constitution. Even Section 89 of the Code of Civil Procedure 1908 provides settling the disputes by way of ADR. The proceedings are flexible and creative. It provides satisfying solutions with reduced cost and time, and thus is an emerging field in law. The Parliament felt the need and passed an act regarding this matter. The article deals with an act of arbitration and conciliation known as Arbitration and Conciliation Act 1996. It lays out the object, extent, and applicability as well as discusses the important provisions under the Act. Now coming to meaning of alternate dispute resolution. According to Harvard Law School Library, alternative dispute resolution is a system of methodologies that parties can use to resolve disputes without resorting to litigation. These include arbitration, mediation, negotiation, and more. As per Hindu law, it is a process that helps the parties who are embodied in a dispute to come to an agreement with the help of a neutral third party. It aims to provide an inexpensive, speedy, and less formalistic remedy to an aggrieved parties. Its purpose is to provide a remedy which is most appropriate in the circumstances of the case. According to Oxford Handbook of Law and Society, ADR is typically used for disagreeing parties who cannot come to an agreement short of litigation. The Oxford Handbook of Law and Society defines ADR as an umbrella term to describe an array of social and institutional methods for resolving disputes. These methods offer individual and collective disputants a panoply of forum, shopping options, and also each taking place in different intrinsic, inherited, and constructed cultural contexts. Now, there are different features of ADR. Voluntary participation. Parties willingly engage in ADR, ensuring a collaborative approach. This fosters a sense of ownership and commitment to resolving the dispute. Number 2, informal setting. ADR processes often takes place in relaxed environment, reducing the stress and promoting open dialogue and encouraging parties to share their concerns and interests freely. Third, neutral third party facilitation. Trained neutral experts guide discussions, ensuring impartiality and effective management of the process. Their neutrality binds trust and encourages constructive conversation. Fourth, flexibility. ADR processes can be customized to suit the unique needs and circumstances of each dispute. This adaptability allows for creative solutions and addresses complex issues. Next feature, confidentiality. ADR maintains confidentiality, allowing the parties to share sensitive information without fear of public disclosure. This confidentiality promotes honest negotiation and open communication. Cost effectiveness, another feature. ADR is often more budget friendly than traditional litigation, reducing financial burden on the parties. This cost effectiveness makes dispute resolution more accessible and efficient. Seventh, time efficient. ADR processes typically resolve disputes more quickly than traditional litigation, saving time and resources. This efficiency allows the parties to move forward with their lives and businesses. Another feature, party control. Parties have more control over the ADR processes and outcome, ensuring their voices are heard and interests addressed. This control promotes satisfaction and acceptance of the resolution. Ninth, focus on interest. ADR explores underlying interests and needs rather than just legal positions, leading to more meaningful resolutions. This approach addresses the root causes of the dispute. Next feature, creative solutions. ADR can lead to innovative solutions that satisfy all parties, going beyond traditional remedies. This creativity fosters a sense of collaboration and mutual benefit. Another feature, preservation of relationship. ADR can help maintain a relationship between parties even in the face of conflict. This preservation is especially important in business, family and community disputes. Expertise. ADR neutrals often possess specialized knowledge in the dispute area, providing valuable insights and guidance. This expertise ensures an informed and effective dispute resolution process. Now, what is the significance of alternate dispute resolution system? Number 1, cost effectiveness. By avoiding costly legal fees and court expenses, the ADR system makes dispute resolution more accessible. Number 2, time saving. ADR streamlines the dispute resolution process, saving time and energy for all parties involved. With faster resolution, individuals and businesses can move forward with their lives and operations. Third, increased control. In ADR, parties have a greater say in the process and outcome, allowing them to make informed decisions and shape the resolution. This control fosters satisfaction and acceptance. Another, relationship preservation. ADR resolve disputes in a collaborative and respectful manner, helping to maintain the relationships between the parties. This is particularly important in business, family and community dispute. Another point, flexibility. ADR adapts to the unique needs and circumstances of each dispute, allowing for tailored solutions. Another, expertise. ADR neutrals bring specialized knowledge to the table, providing valuable insights and guidance. This expertise ensures a well-informed and effective dispute resolution process. Next, confidentiality. ADR maintains confidentiality, allowing the parties to share sensitive information without fear of public disclosure. This confidentiality promotes open communication and honest negotiation. Eighth, reduced stress. ADR offers a less confrontational and stressful approach to conflict resolution, reducing emotional strain on parties. This leads to a more constructive and respectful dispute resolution process. Ninth, improved satisfaction. With more control and input, parties are more likely to be satisfied with ADR outcomes. This satisfaction ensures acceptance and implementation of the resolution. Another point, access to justice. ADR increasing access to justice for marginalized groups by providing an accessible and affordable dispute resolution process. This ensures a fair opportunity for all parties to resolve the disputes. Next, court congestion reduction. ADR helps alleviate the burden on the court system by resolving disputes outside the court. This allows the courts to focus on complex and critical cases. Another, community cohesion. ADR resolves disputes within communities, promoting understanding and respect among community members. This preserves the relationships and social bonds. Next, creative solutions. ADR encourages innovative solutions by promoting collaborative thinking. This leads to meaningful and lasting solutions. Another point, trust building. ADR fosters trust between parties and in the dispute resolution process through open communication and collaboration. This trust ensures acceptance and implementation of the resolution. Now, let us talk over the merits of the alternate dispute resolution system. First, speedy resolution. ADR processes swiftly resolve disputes, saving valuable time and energy for all the parties. Another merit, cost effective. ADR reduces the financial burden on the parties by avoiding costly legal fees and court expenses, making it the dispute resolution more accessible and efficient. Flexibility. ADR adapts to the unique needs and circumstances of each dispute, allowing for tailored solutions that address the complexity of the issues. Confidentiality, another feature and a merit. ADR maintains confidentiality, creating a safe space for open communication and honest negotiation, leading to more constructive and respectful dispute resolution. Expertise, another merit. ADR neutrals being specialized knowledge and expertise, providing valuable insights and guidance that have well-informed dispute resolution process. Another merit, party control. In ADR, parties have a greater say in the process of outcome, allowing them to make informed decisions and shape the resolution. Another merit, preservation of relationships. ADR resolves disputes collaboratively, helping maintain relationship between parties, which is particularly important in business and community disputes. Reduces the stress, another merit. ADR offers the reducing of emotional stress on the parties and leading to more constructive and respectful dispute resolution process. Increased satisfaction. Parties are more likely to be satisfied with ADR outcome due to their involvement and control, ensuring the acceptance and implementation. Access to justice. ADR increases access to justice for marginalized groups by providing an accessible and affordable dispute resolution process, ensuring a fair opportunity for all the parties. It reduces the court burdens. ADR alleviates the burden on the court systems by resolving the disputes outside the court and allowing the courts to focus on critical cases. Creative solutions. ADR encourages innovative solutions by promoting collaborative thinking that leads to meaningful and lasting resolutions. Building trust is another benefit. ADR fosters trust between parties and in the dispute resolution process through open communication and collaboration, ensuring acceptance and implementation. Another merit, efficient use of resources. ADR allocates resources more efficiently by avoiding unnecessary legal expense and court time, leading to a more cost-effective dispute resolution process. Next, improved communications. ADR promotes open and effective communication between parties, leading to better understanding and resolution, improving relationships and preventing future disputes. Now, there are some demerits of the alternate dispute resolution system. Number 1, lack of legal precedent. ADR outcomes may not set legal precedents which can limit their impact on future cases. This makes it challenging to establish consistent legal standards. Limited enforceability. ADR agreements may be difficult to enforce, potentially leading to non-compliance. Another demerit, inadequate representation. Parties may not have equal access to legal representation, creating an uneven playing field. Lack of pro bono services or legal aid could be a factor. Another point of demerit, power imbalance. ADR may favor the more powerful party, perpetuating existing inequalities. Another point, lack of transparency. ADR processes can be secretive, making it difficult to assess their fairness and effectiveness. Another point, inadequate discovery. ADR may limit the exchange of information, potentially leading to uninformed decisions. Another point, no appeal. ADR decisions are often final and binding, leaving little room for error. Another, quality of neutrals. ADR relies on the quality of neutrals, which can vary significantly, leading to inconsistency. Another disadvantage, cultural and linguistic barriers. ADR may not account for cultural or linguistic differences, potentially leading to misunderstandings. Another point is inadequate regulation. ADR may lack standardized regulations, creating uncertainty and inconsistency. Another demerit, limited public accountability. ADR outcomes may not be publicly disclosed, limiting public scrutiny and accountability. Another point, risk of bias. ADR neutrals may bring their own bias to the processes, potentially influencing outcomes. Another point of demerit, inadequate training. ADR neutrals may not receive adequate training, potentially compromising their effectiveness. Another point, dependence on party cooperation. ADR requires cooperation from all parties, which can be challenging to achieve. Building trust and fostering collaborative relationship can be difficult. Another point, incompatibility with complex cases. ADR may not be suitable for complex or high-stake cases requiring specialized expertise. Now let's discuss some of the different types of alternate dispute resolution systems. First is mediation. Mediation empowers the parties to reach a mutually acceptable agreement with the guidance of a neutral facilitator. This collaborative approach fosters creative solutions and preserves relationship. Number 2, arbitration. Arbitration provides a binding decision from a neutral expert, offering a more structured approach than mediation. Parties can choose from various arbitration styles, including document-only or in-person hearings. Third type is conciliation. Conciliation helps the parties identify common goals and interests, facilitating a settlement. This process emphasizes understanding and cooperation, leading to more sustainable agreements. Fourth type of ADR is negotiation. Direct negotiation between the parties allows for open communication and creative problem solving. This approach is often the simplest and the most cost-effective way to resolve the disputes. Fifth type, mini trial. A mini trial provides a brief, informal trial experience, giving the parties a taste of what to expect in a full trial. This can prompt settlements or more focused negotiations. Sixth type, neutral evaluation. Neutral evaluation offers an expert's objective assessment of each party's case, highlighting the strengths and weaknesses. This can help parties set realistic expectations and negotiate more effectively. Seventh type, ombudsperson. An ombudsperson investigates and resolves the dispute within a specific industry or sector, providing expertise and impartiality. This approach is particularly useful for resolving systemic issues. Eighth type, collaborative law. Collaborative law encourages the parties to work together with their lawyers to reach a settlement. This cooperative approach prioritizes open communication and creative problem solving. Ninth type is restorative justice. It focuses on repairing harm and promoting healing between victims, offenders, and the community. This approach addresses the emotional and social aspects of the conflicts. 10th type, that is the ODRs, online dispute resolution. ODR leverages technology to resolve disputes, often through online mediation or arbitration. This approach increases accessibility and efficiency in dispute resolution. 11th type, early neutral evaluation. Early neutral evaluation provides an expert's assessment of the case early in the litigation process, helping the parties identify potential outcomes and adjust their strategies accordingly. 12th type, MED-ARB, that is a combination of mediation and arbitration, allowing the mediator to become the arbitrator if mediation fails. This approach offers flexibility and efficiency. 13th type, ARB-MED. ARB-MED reverses the MED-ARB process, with the arbitrator becoming the mediator if the arbitration fails. This approach allows the parties to adjust their approach midstream. 14th type, neutral fact-finding. Neutral fact-finding involves an expert investigating and reporting on the facts of the case, providing clarity and context to further negotiations and decision-making. 15th type, dispute resolution boards. It consists of a panel of experts providing the non-binding recommendations to resolve the disputes. This approach offers a collaborative and informed perspective on complex issues. Now let's come over to the emerging trends in forms of alternate dispute resolution. The world of ADR is evolving and technology is playing a significant role in shaping its future. Here are some of the emerging trends in forms of ADR. Number 1, virtual ADR. It provides a hassle-free resolution to disputes, eliminating the need for parties or attorneys to travel. Both parties can communicate through video conferencing, allowing them to hear and see each other. Number 2, ODRs, that is online dispute resolution. It is becoming increasingly popular, especially in context of intellectual property disputes. It offers a convenient and cost-effective way to resolve the disputes. Next, third is artificial intelligence in ADR. AI is revolutionizing various sectors and ADR is no exception. AI can help in predicting the outcomes, identifying the patterns and streamlining the dispute resolution process. Number 4, digital mediation platforms. Digital mediation platforms are emerging, offering a range of tools and services to facilitate online mediation. These platforms provide a convenient and efficient way to resolve the disputes. Fifth is e-arbitration or e-courts mission project. E-arbitration is gaining popularity, especially in international commercial arbitration. It offers a flexible and cost-effective way to resolve the dispute. The Indian government has launched this project to improve the access to justice using technologies. Courts are using technologies to hear the cases virtually, and traditional courtrooms are being replaced by online platforms. These emerging trends in forms of ADR are transforming the way disputes are resolved, making the process more efficient, cost-effective and convenient. Now comes the benefits of e-ADR. Number 1, cost-effective. E-ADR is a pocket-friendly alternative for both parties, excluding the need for travel or renting facilities for dispute resolution. Number 2, convenient and quick. E-ADR offers a faster way to solve cases and simplify the way of resolving the disputes. It allows the parties to submit their arguments online, making it convenient for people with busy schedules. Number 3, customizable processes. E-ADR allows for organized and customized dispute resolution processes, making them more cost-effective
and beneficial for specific cases.
Fourth, encourages dispute resolution. EADR promotes the mutually agreeable resolutions, making it more accessible and also improving the overall experience. Number 5, limits implicit bias. EADR reduces unconscious bias in resolving the disputes as the processes are clear to everyone. Now, there are latest case laws in this regard. Let's discuss. AT&T Mobility LLC versus Concepcion. The context is the Concepcion filed a class action lawsuit against AT&T Mobility alleging false advertisement. AT&T sought to compel the arbitration, citing the arbitration clause in their contract. It was held by the Supreme Court that the Federal Arbitration Act preempts the state laws that prohibits the arbitration agreements from including class action waivers. The court ruled in favor of AT&T, allowing them to compel the arbitration. Another case, Marmot Healthcare Center versus Brown. The Brown filed a wrongful death lawsuit against Marmot Healthcare Center alleging the negligence. Marmot sought to compel arbitration, citing the arbitration clause in the admission agreement. The Supreme Court held that the FAA preempts the state laws that prohibit the arbitration agreements in the wrong death cases. The court ruled in favor of Marmot, allowing them to compel arbitration. Another case, Kindred Nursing Centers LP versus Clark. The Clark filed a lawsuit against the Kindred Nursing Centers alleging the wrongful death. Kindred sought to compel arbitration, citing the arbitration clause in the admission agreement. Later on, the Supreme Court held that the FAA preempts the state laws that prohibits the arbitration agreements in the wrongful death cases, but also held that the arbitration clause in this case was not enforceable due to lack of clear and unmistakable language. These cases demonstrate the ongoing development of alternate dispute resolution system in the United States, particularly in the context of arbitration agreements and the Federal Arbitration Act. Now, there is a difference between litigation and alternative dispute resolution system. First aspect is the definition. Under litigation, it is a formal process where a case is brought before the court, and whereas in alternate dispute resolution, it is an informal process like mediation, arbitration, etc. Another aspect is the control. In litigation, judges control the process. In ADR, the parties have more control over the process. Third aspect is formality. In litigation, it is highly formal with strict rules of procedure, while ADR, it is less formal and flexible procedures. Next aspect is time. Litigation is often lengthy, can take years, whereas ADR is generally quicker and can be resolved in months. Another aspect is cost. Litigation can be very expensive due to legal fees and cost, whereas the ADR is usually less expensive. Another aspect is confidentiality. In litigation, there are public records, proceedings are open to the public, whereas ADR, it is totally private and confidential. Another aspect, outcome. In litigation, the binding decision is given by the judge or the jury. In ADR, it can be binding in case of arbitration or non-binding in case of mediation. Another point, appeal. In litigation, decisions can be appealed to higher courts, whereas in ADR, it's a limited or no right to appeal. Another aspect is relationship impact. In litigation, it is often adversarial, can damage the relationships, whereas in ADR, it is more collaborative, can preserve the relationship. Next aspect is enforcement. In litigation, the court enforces the judgment, whereas in ADR, the enforcement depends upon the type of the ADR used. Now, let's conclude the topic. Imagine resolving disputes without the need for costly and time-consuming lawsuits. Alternate dispute resolution makes this possible. By offering a range of approaches from mediation to arbitration, ADR helps individuals and organizations find creative solutions to complex problems. One of the biggest advantages of ADR is its ability to preserve relationship. By focusing on collaboration and mutual understanding, ADR helps the parties to work together and work for everyone. While ADR isn't perfect, its benefits far outweigh its drawbacks. It's often faster, more affordable, and more flexible than traditional litigation. The rise of online ADR platforms has made resolving disputes easier than ever. With just a few clicks, parties can connect with mediation arbitrators from around the world. Recent court decisions have also recognized the value of ADR in reducing court congestions and promoting access to justice. In short, ADR is a powerful tool for resolving disputes in a more humane and effective way. By embracing ADR, we can create a more collaborative and compassionate approach to a conflict resolution. Thank you everyone for your valuable time and attention. I also appreciate this opportunity to speak and share my views with you today. Thank you once again. Take care. God bless you all.